Hi everyone, my name's Nathan Turk. I'm a senior lawyer at the Australian Government Solicitor, and today I'll be talking about the issue of ownership of space and how this is dealt with under international law. And I'm planning to cover a few major points here. So first of all, how does international law deal with ownership of space currently? Secondly, what are some of the issues with the existing law in this area? Thirdly, I'll look at some of the arguments around whether states and non-state entities should be able to own areas of space. And finally, I'll say a couple of brief words about the types of governance models that might be adopted here if we wanted to change or at least clarify the law in this area. But just before I get into it, I just wanted to be clear up front that although I do work for the Australian government, I'm certainly not speaking on behalf of the government here, and I'm not expressing any views about the government's legal or policy positions in this area. These are just my personal views, and I'm really just coming at this from a purely academic perspective. And my aim today is really just to give you a broad outline of some of the key issues in this area, and also just to give you a sense of how some academics and other people are currently thinking about these. Okay, with that said, let's get into it. And I think a useful starting point here when we're talking about the ownership of space is to think about how international law would govern a particular scenario. So let's take a hypothetical and entirely fictitious situation. Let's say it's the year 2100, and we've just discovered a new planet which has some new substance we've never seen before, and which is going to give us some new amazing source of energy that'll finally enable interstellar travel. So naturally, this is something that people would probably want, but even with the technology we've got in the year 2100, getting this material isn't going to be easy. Obviously, we're going to have to get to the place first, set up long-term mining operations, mine the material, and then somehow get it back to Earth or some other base of operations. And obviously, this is going to be a very complex task, and one which involves a lot of expense and also a significant amount of risk for anyone who takes this on. That said, the possible rewards here are just too good to resist, so a new company, let's call it Starbound Enterprises, launches a mission from a country here on Earth. Let's call it Country X. And eventually, Starbound Enterprises does make it to this new planet and manages to get their mining operations up and running. Okay, so that's the hypothetical scenario. The first legal question here is, could Country X claim sovereignty over all, or at least part of, this new planet? Well, the basic principle here, which has been agreed under the UN-sponsored Outer Space Treaty, is what's commonly called the non-appropriation principle. And this principle is quite clear in saying that no, states can't claim sovereignty over outer space, and that this prohibition extends to celestial bodies like the one in our scenario. So as things currently stand, we might say, well, that answers that. Country X clearly can't claim sovereignty over any part of this planet. Where things start to get interesting, though, is when we start to think about, well, what does this mean for our company, Starbound Enterprises? Well, to answer that question, let's take a bit of a closer look at the Outer Space Treaty and this non-appropriation principle. And a good starting point here is to look at Articles 1 and 2 of the Outer Space Treaty, and there are basically three key points here. First, there's the statement in Article 1 that outer space shall be the province of all mankind. Secondly, there's the statement also in Article 1 that space is to be free for exploration and use by all states, and also that there's to be free access to all areas of celestial bodies. And the third point here is the statement in Article 2 that outer space, including the moon and other celestial bodies, is not subject to national appropriation by a claim of sovereignty or by means of use or occupation or by any other means. So these few provisions from the Outer Space Treaty are generally recognised as providing the foundation for the non-appropriation principle in the outer space context. Now, I should say here that there's another treaty, the Moon Agreement, that seeks to build on this foundation and develop these provisions in some more detail. And so for states like Australia, which are party to the Moon Agreement, there's this extra layer of international law that needs to be complied with. And I will be briefly mentioning some of the provisions of the Moon Agreement a bit later on. But coming back to our hypothetical scenario and the question of, well, what does this all mean for our company, Starbound Enterprises? Well, one thing that's notable about the provisions of the Outer Space Treaty is that they make it quite clear that states can't appropriate outer space, but they don't make any explicit mention of private or non-state entities. And so this has led some commentators to argue that the non-appropriation principle only prohibits national appropriation by states, but does allow for private appropriation by non-states. So in our scenario, this would still mean that country X can't claim sovereignty over this new planet, but it'd also mean that there's nothing to prevent Starbound Enterprises from claiming private ownership over at least part of the planet. So, for example, the area of its mining operations. Now, this argument might, on one view, seem to make sense, given that these concepts of national appropriation and private appropriation do seem to be two fairly distinct concepts. On the one hand, national appropriation would seem to be fairly closely related to the idea of sovereignty. And this suggests a number of things, including, for example, that a state has territorial authority over an area, and that this authority gives them the right to make and enforce laws over the area. On the other hand, private appropriation seems to be more about this idea of private ownership. And in legal terms, this is typically thought of as a collection of rights which are enforceable under under national law. And these give individuals and private entities a number of different entitlements, including, for example, right to control or sell whatever it is that they own. So given this distinction between these two concepts, some argue that if the intention had been for private ownership to be covered by the non-appropriation principle, then the Outer Space Treaty would have been drafted to say this explicitly, rather than just referring to the concept of national appropriation. So based on this, the Outer Space Treaty should, they would argue, be interpreted to allow private entities to own space resources. Having said this, there are quite a few commentators who take the other view, that private ownership is prohibited by this principle. Now, these commentators don't tend to deny that there's a meaningful distinction between national sovereignty and private ownership. What they do argue, though, is that these two concepts are basically linked, in that you can't have private ownership without state sovereignty. And there are basically two main reasons for this. The first relates to this notion I mentioned before, that private ownership is typically thought of, at least in legal terms, as a bundle of rights that are enforceable under national law. Now, the important point here is that basically this would seem to suggest that private ownership can't exist in the absence of the state. So in other words, if we have any private property rights, this is only because the state has granted us these rights. and that in this sense, private ownership really depends on the state having the ability to grant us these rights, which in turn depends on the state having sort of a superior form of authority over the things we own. And again, just talking in legal terms here and putting aside any sort of philosophical ideas about the nature of ownership outside the law. And so basically the argument here is that because states can't claim this superior authority over outer space, this also means that they don't have the authority to enforce any private property rights in that context, and that therefore private property rights simply can't exist. So that basically this is one argument to say that the non-appropriation principle effectively does prevent private ownership. The second argument here is based on Article 6 of the Outer Space Treaty, and this says, firstly, that states bear international responsibility for national activities in outer space, and that this applies even where it's a non-government entity that's undertaking these kinds of activities. The provision then goes on to say that states have an obligation to authorize and continually supervise the activities of their non-government entities in space. The key point here for many commentators is that basically, even if it's a non-government entity that carries out activities in space, then under these provisions, it's the relevant state that's taken to be responsible for those activities. So say, for example, Starbound Enterprises, in our example, in our scenario, gets to this new planet and says, yep, okay, we own this place now. Well, from an international law perspective, it'd be country X that's taken to be responsible for this act of appropriation. And so based on this, many commentators argue that basically we shouldn't interpret the Outer Space Treaty in a way that allows non-government entities to do something that would be a breach of international law by their state. And so it follows on this argument that the treaty shouldn't be interpreted to allow for private ownership. Okay, so this is just one of the issues that's currently being debated in this area. I should say that for states that are party to the Moon Agreement, the legal position here is actually a lot more straightforward. Article 11.2 of that agreement starts out by basically affirming the general position under the Outer Space Treaty that the Moon isn't subject to national appropriation by claim of sovereignty or by any other means. Article 3, though, then goes on to say that neither the Moon nor any part of the Moon or any natural resources in place shall become the property of any state, any kind of international organization, any national organization, or any non-governmental entity or a natural person. And then by Article 1, this prohibition also covers other celestial bodies in the solar system besides the Moon. So this would seem to make it quite clear, at least for the states that are party to the Moon Agreement, that the non-appropriation principle applies equally to both states and non-states, as well as international organizations. But as I say, for other states which aren't party to the Moon Agreement, the position at international law is somewhat less certain. Okay, so that's one issue. A second issue that's often brought up in this context of ownership of space, again, has to do with the scope of the non-appropriation principle. And in particular, it's the question of whether states and non-state entities can own materials that have been extracted from a celestial body. So coming back to our hypothetical scenario again, even if we accept that starbound enterprises can't own land on this new planet, one of the questions would be, well, can it at least own the stuff that it mines from the land and then transports back to Earth? And again, a good starting point here is the Outer Space Treaty. There are some commentators who argue that the non-appropriation principle does prohibit ownership of extracted space resources. And for them, a key point here is that the treaty doesn't make any distinction between space on the one hand and the things that are located in space on the other. If we look at Article 1, for example, which again is generally seen as the foundation for the non-appropriation principle in this context, the provisions there are just broadly stated to apply to outer space, including the moon and other celestial bodies. There's certainly no explicit exception there for extracted resources. And so basically the argument goes that just based on this wording, the non-appropriation principle applies to all space resources, whether they've been extracted or not. Now, on the other side of the debate, there are quite a few commentators who take the other view, that extracted space resources can be owned. And these people basically argue for a narrower interpretation of the Outer Space Treaty. And there are at least a couple of reasons that they give for this. The first, again, has to do with the language of the treaty, and in particular the provision in Article 1, which protects freedom of exploration and use of outer space by all states. The key thing here is this notion of free use. And many commentators focus in on this and argue that free use should be interpreted to include any activities that involve extracting resources, but with one important caveat, which is that these activities are only permitted as long as they don't prevent others from accessing the same resource. And with this, basically, this is how how this argument basically tries to reconcile these two concepts of free use and non-appropriation. So in other words, the argument is saying that, sure, you can take resources from, say, another planet. What you can't do, though, is claim that you're the only one who's allowed to do it. You have to allow others to access the planet, including the areas of your mining activities. And if you don't, you'll be in breach of this non-appropriation principle in international law. Now, many commentators often point to state practice as for support to support this interpretation. Of course, over the years, countries have actually taken samples of material from space for scientific purposes, and they seem to have done so without any objections from other countries. So, for commentators on this side of the debate, given that states don't seem to object to this, this clearly suggests for them that states accept that you can own extracted materials. Now, this may well be, and maybe we can say that based on state practice, resource extraction isn't completely banned by the non-appropriation principle. What's not entirely clear, though, is whether it allows for all kinds of extraction. So, for example, does it allow for large-scale commercial extraction or mining? Or does it only allow for extraction for certain limited purposes, like, for example, scientific sampling? On the one hand, Article 1 of the Outer Space Treaty does explicitly protect freedom of scientific investigation in space. And this might partly help to explain why states seem to accept extraction of materials for scientific purposes. On the other hand, there's no explicit authorization in the treaty for commercial extraction. Still, though, some states clearly do take a view that the non-appropriation principle does allow for commercial extraction. And in fact, the US and Luxembourg, for example, have even adopted domestic legislation which reflects this position. Ultimately, though, when it comes to international law, many commentators seem to think that the position here is still, at least currently, unsettled. Now, it's also just worth mentioning here, again, the Moon Agreement, and this is another area where certain provisions of the Moon Agreement have some relevance, at least for the parties to that agreement. Now, I've already mentioned Article 3 of the Moon, Article 11.3 of the Moon Agreement, and again, just as a reminder, this says that the Moon, that neither the Moon nor any part of the Moon or any natural resources in place shall become the property of any person. The key thing here is this reference to natural resources in place. And a number of commentators see this as an important qualification on the non-appropriation principle. And basically their argument is that once a resource has been removed or extracted, well, it's no longer in place. And then this then puts it outside of the non-appropriation principle as described in Article 11.3. And this ultimately means that the extracted resource can be owned. Also, just very quickly, it's worth mentioning Article 11.5 of the Moon Agreement as well. Under this article, the parties to the Moon Agreement have undertaken to establish an international regime which governs the exploitation of natural resources of the Moon, as such exploitation is about to become feasible. The key thing here is this reference to the exploitation of natural resources, and we might see this as a bit of a clearer recognition that commercial mining in space, or at least on the Moon anyway, might be permitted. Although there is even some debate here about whether Article 11 effectively prohibits these activities before the relevant international regime has been established. I won't get into that now, but again, it's just worth mentioning this article here, given that this is something that parties to the Moon Agreement anyway have obviously accepted. Okay, so just to quickly recap, I've talked in a bit of detail now about the non-appropriation principle. I've mentioned a couple of issues with this principle. First of all, does it apply to both states and non-state entities? And secondly, does it allow for ownership of extracted space resources? And if it does allow for ownership of those kinds of resources, then does it allow this in the context of purely commercial activities? Or does it only allow this for certain limited purposes like scientific sampling? I should say that here that I certainly haven't covered all of the different arguments that are made on these couple of issues. And in fact, there are other important issues in this area that I haven't even mentioned yet. So to name just some of these, there's the legal question of, well, what is space and where does it begin? And there are also some further questions about the meaning of certain other aspects of Article 1 of the Outer Space Treaty, which I won't get into here. As I say, these are just some of the issues in the area and some of the arguments in the area, and no doubt you could devote a whole hour to each of these issues. And obviously, I don't have the luxury of time to do that now. Really, the key thing to keep in mind, and the key point for my presentation here, is just that under international law, as it currently exists, there are these significant uncertainties around the scope of the non-appropriation principle. Now, again, let's come back to our hypothetical scenario and think about, well, what does this uncertainty mean? What could it mean for our two stakeholders there, Country X and Starbound Enterprises? Well, for one thing, it could mean that Country X is left feeling uncertain about its position about its ability under international law to authorise and legally protect star-bound enterprises' proposed mining operations. And to the extent that it can't protect those operations, this potentially creates a significant problem for star-bound enterprises. Obviously, an operation like this would take a huge investment of time and resources for the company, and so no doubt star-bound enterprises is going to want to have an assurance that they can legally protect their operations. What happens, for example, if a competitor of the company decides to try to establish a mining operation in the exact same area? Can star-bound enterprises then take their competitor to court in country X? Will the law give them any kind of remedy if their competitor seeks to interfere with the operations of star-bound enterprises? Well, if the company can't rely on the law to protect their investment, then it might well just decide that it's simply not worth the risk of doing this. It's this kind of scenario or situation that moves a lot of commentators to argue that there's an urgent need to clarify the law in this area. Why is this important? Well, on the one hand, we probably want to avoid a situation where different countries adopt conflicting domestic policies on this issue. If we have conflicting domestic policies, then this could potentially lead to the fragmentation of international space law, which would ultimately just undermine the rules-based international order in this area. Having clear international legal standards, though, is one way to help avoid this situation. Besides this, many commentators argue that if private entities were given confidence that the law would protect their commercial activities in space, then this would help to encourage more private sector investment in the area. And why do they say this matters? Well, it's obviously a fact that governments are no longer the sole actors here. In recent years, the private sector has played an increasingly significant role in space exploration and other activities. And this, for many commentators, seems to mark a new era in human activity in space. And a lot of commentators note that there are also a number of benefits that have come from this. So, for example, lower costs and advancements in technology. And so on this view, well, some states obviously might want to encourage more private sector involvement in the area, and law reform is just one way to help do this. Okay, so that's a couple of reasons why we might want to change or at least clarify the law in this area. This just leaves the question of what types of governance model could we adopt here. Well, this is going to be more of a question of policy for states rather than a legal question, I would say. From a legal perspective, states can basically agree to adopt any kind of governance model they want, provided though that they make sure that they don't go against any broader restrictions that apply to them under international law. So as things currently stand anyway, these restrictions would include, for example, any obligations that they've accepted under the Outer Space Treaty, and for some states, the Moon Agreement. And it would also mean not going against the so-called peremptory norms of international law. Now, there are many different suggestions in the literature about the type of governance model that could be adopted here. And actually, there's just way too many for me to even begin talking about in any real detail here. So I thought I'd just make one general observation here, which is that when we're thinking about a new model in this area, it's not necessarily just an all or nothing sort of choice between whether to allow or not allow sovereignty and private ownership in their fullest sense. A state's authority over an area can be less than the authority that it has over its own territory. So take, for example, the limited rights that coastal states have over their exclusive economic zones under the international law of the sea. Likewise, the property rights that a private entity has over land can be less than it would have with full ownership. So you're thinking, for example, of a lease or license arrangement. What this means is basically that when it comes to defining the authority that states can have in space, or the property rights that private entities can have in this context, states can basically tailor these things to suit their particular policy objectives. So this could mean, for example, that a company like Starbound Enterprises is given certain exclusive rights over an area of space, but that these are only granted on a temporary basis and might come with certain obligations attached. So, for example, an obligation to maintain the area of its mining operations to a certain standard, and an obligation to allow access by certain other people, like, for example, scientists. And in this way, states could basically try to formulate these kinds of rights in order to achieve a sort of a balance between different competing interests here. So this might include, for example, trying to balance the interests of the scientific community, the commercial sector, and environmental groups. Now, with that, I'll just leave you with one final comment, which is that it's certainly not just academics who are interested in the issues I've been talking about here. These are actually very live issues which are currently being thought about at the international level. And in fact, the legal subcommittee of the UN Committee on the Peaceful Uses of Outer Space currently has a working group that's considering some of these issues. Now, I'm not personally involved with that group in any way, but you can find more about the work of this group online. One interesting thing to note here is that as part of its mandate, this group might eventually be preparing a set of initial recommended principles for activities in the exploration, exploitation, and utilization of space resources. And so it'll be quite interesting to see what ultimately comes out of this. And with that, I'll leave it there. Thank you.